Senate bills. So the very first bills are Senate Bill 982, and Senator McCray has his assistant here, and then House Bill 1616 is Delegate Rogers, and we're going to come to the table together. It's the same bill. So, Delegate Rogers, would you like to start?
Yes, ma'am.
Okay.
Good afternoon, Chair Bidle, Vice Chair Hayes, and members of the mighty Finance Committee. For the record, Delegate Mike Rogers, Legislative District 32, here in support of House Bill 1616, Mutual Insurance Holding Companies Conversion to Mutual Insurers. House Bill 1616 is identical to Senate Bill 982 and passed the House unanimously with no amendments or opposition. It's a straightforward technical bill that fills a gap in Maryland's existing law. In 2000, the General Assembly enacted the Mutual Insurance Holding Company Act, allowing mutual insurers to reorganize into a hybrid holding company structure. However, that law provided no mechanisms for companies to convert back to their original mutual insurer from what House Bill 1616 creates a pathway to do that. This bill applies only to holding company systems that remain 100% policy-owned, so no outside investors are affected. It mirrors the existing conversion process, preserves all current policy protections, and keeps the Maryland Insurance Administration oversight and approvals requirements intact. We worked with MIA during the interim to develop the approach. The MIA has reviewed the bill, raised no concerns, and confirmed it carries no fiscal impact. The change will likely be used rarely, but it gives companies an important option to shed any unnecessary complex structure and reduce administrative costs ultimately borne by Maryland policyholders. So with that, I respectfully request a favorable report on House Bill 1616.
Delegate Rogers, you did a great job. Greg, do you have anything you want to add?
Yes.
Okay.
Good afternoon, Madam Chair, Vice Chair, and members of the committee. For the record, my name is Gregory Baugh. I'm an intern working in Senator McCray's office, here to speak on his behalf regarding Senate Bill 982, legislation that establishes a clear and structured pathway for mutual insurers holding companies to convert back into mutual insurers. This bill authorizes a mutual insurance holding company that fully owns a reorganized stock insurer to convert its system into a mutual insurer through a formal plan of conversion. Importantly, the legislation outlines comprehensive requirements to ensure transparency, accountability, and fairness throughout the process. Senate Bill 982 requires that any plan of conversion be approved by both the Board of Directors and at least 75% of voting members, ensuring strong stakeholder support. Additionally, the bill mandates review and approval by the Maryland Insurance Commissioner, including the submission of key materials such as governance documents, a 5-year operational plan, and leadership disclosures. These provisions help safeguard policyholders and maintain regulatory oversight. The bill further protects policyholders by ensuring continuity of existing insurance policies, preserving membership interests, and requiring that the converted mutual insurer maintain adequate surplus funds for financial security. By establishing these protections, Senate Bill 982 promotes stability while allowing insurers the flexibility to modernize their organizational structures. We ask for a favorable report for Senate Bill 982. Thank you.
Thank you. Gregory, do you know what the vote was in the Senate? Was it unanimous?
I'm sorry, I'm not sure.
Okay, thank you. We can look it up. Do I have any questions for these, I think, identical bills? Seeing no questions, that ends the hearing on House Bill 1616 and Senate Bill 982. Thank you very much. Okay, next we have House Bill 939, Certificates of Birth, Filing, and Time Period, and it's Delegate Rosenberg's bill, but I think his Deputy Chief Malik Gupta is going to present.
All right. Okay. Good afternoon, Madam Chair, members of the committee. A special hello to Senator Washington, who was my representative until I left for Greenbelt a little while ago. But anyways, my name is Malik Gupta, Delegate Rosenberg's Deputy Chief of Staff for this session, here to support House Bill 939, which just allow parents to request a 5-day extension to the current 5-day deadline to prepare and file a certificate of birth. And Delegate Rosenberg's written testimony kind of shows who the two groups are that we're targeting with this legislation, but of course it's by no means limited to them. The first group is the Orthodox Jewish community, who canonically is required to not name their newborn boy until the 8th day after birth, and to add to that, newborn girls are traditionally named in a ceremony in synagogues with the reading of the Torah, which again may occur after the 5th day. And then the second group, of course, are nurse midwives, who are oftentimes solo practitioners who are assisting with childbirth. Now, I have never been in a delivery room, whether in a hospital setting or otherwise. I don't plan to in near future, but my sister, who works at GBMC in the labor and delivery unit, informed me yesterday that there's generally 6 different people in a delivery room in a hospital. That's the primary nurse, the charge nurse, the RN student, 2 baby nurses, and the physician. And this is all for a perfectly healthy baby and a perfectly healthy mother. So all that is to say that those 6 roles converge onto the midwife when they are assisting with the birth, which means that our current 5-day deadline is burdensome for them to meet. So with this extra 5 days, it'll make it easier for them. So with that, our neighbors, Pennsylvania, Delaware, Virginia, and West Virginia, they all have more generous timelines, around 7 to 10 days. So we just believe that Marylanders should be afforded that same benefit. And then we also have an amendment submitted for y'all's consideration. That's just the MDH amendment. It's the same substantively of what was passed unanimously in the House, but it just clarifies what the exact process would be in practice for parents to request the extension. So with that, I know there's some buzzwords I should include in the testimony, so I'll just throw those out here. This bill is bipartisan. It's common sense, makes only a narrow change to existing law, and there's no fiscal impact. So with that, I'd appreciate a favorable report, and I'm happy to take any questions, including why the bill sponsor's not here.
You did a fine job. We don't need that bill sponsor. Do I have any questions at all for this witness? We know where he is. So thank you very much for your testimony.
Thank you.
Seeing no questions, that ends the hearing on House Bill 939. And now we have Delegate Boafo, I think, House Bill 1191. And it looks like we have Maddie coming up. Thank you, Maddie. 1191.
Good afternoon, Madam Chair, Vice Chair, and members of the Senate Finance Committee. For the record, my name is Maddie Mara, and I'm testifying on behalf of Delegate Boafo on House Bill 1191. I do want to note that this bill passed out of the House 126-3 and out of the Economic Matters Committee unanimously. So this is a modernization bill. It updates Maryland's laws on secondhand precious metal and gemstone dealers to reflect how the market operates today. In recent years, we've seen the growth of estate buyers who purchase jewelry, coins, and valuables outright. These businesses are not pawnbrokers. Instead, they partner with local jewelers to host short-term buying events, giving consumers a convenient and transparent way to sell inherited or unused items. These events benefit everyone. Consumers receive professional valuations and competitive offers, and Maryland jewelers gain foot traffic and new customers. The challenge is that Maryland's current law, written in 1981, does not clearly account for this type of event-based activity. As a result, legitimate businesses face unnecessary administrative hurdles because the law has not kept up. HB 1191 fixes that. It requires operators to follow the same core safeguards as all secondhand dealers, reporting items to law enforcement, holding them for a set period to ensure they are not stolen, and complying with the applicable licensing requirements. This bill does not reduce oversight. In fact, it strengthens it by bringing this activity into a clear, regulated framework. I want to note that the Department of Labor supports this bill and has worked with us to ensure appropriate oversight is maintained. In closing, HB 1191 creates a limited license for event-based dealers while preserving consumer protections and law enforcement visibility. And for these reasons, I respectfully ask for a favorable report. Thank you.
Thank you, Maddie. Do I have any questions at all? No questions on House Bill 1191. Thank you for your testimony. Now we're going to go to Delegate Phillips, House Bill 1216. I think. Is anybody here for Delegate Phillips? All right, we'll get back to that one. House Bill 103, Delegate Stewart, Consumer Protection, Consumer Contracts, Prohibited Waiver. Now, we have some unfavorables, Delegate, but would you like to bring Christine Hines up with you?
I would love to, Madam Chair.
All
Thank
right,
you.
Christine, please come to the table. Thank you.
All right, thank you, Madam Chair, Mr. Vice Chair, honorable members of the Finance Committee, Senator Kramer. My name is Vaughn Stewart. This is House Bill 103. So this bill passed in a bipartisan nature out of the House, and it is pretty simple. It simply says that in consumer contracts, companies cannot bury in the fine print language that purports to have consumers waive their right to statutory or punitive damages. This builds on the work that we did last session, a bill that came out of Finance, I believe unanimously, and out of the Senate unanimously last year, that had a similar provision about statutory periods, statute of limitations periods, basically saying that when the legislature designates a statutory period as the time that people can sue, we shouldn't have companies burying in the fine print language that essentially seeks to overrule what we, as their elected representatives, have designated for statutory periods. This bill extends it a little bit further into the damages arena for areas where we have said that in order to basically deter corporate malfeasance or misconduct in some way, we have put either statutory or punitive damages in place. And so the bill simply says you can't purport to waive them. Now, what I will say is a couple things. First, a lot of courts in a lot of different states have already held provisions like this as null and void, as against public policy. So I don't think this is necessarily a sort of substantive change as much as it is codifying probably what is existing, what exists as a violation of public policy. And in that way, I think we're adding some legal clarity. The other thing I'll note is that the bill started out way more ambitious, and we worked with Mr. Enton, your friend, with the bankers. We've continued to work with Mr. Wiggins, with the Chamber of Commerce. I think we have almost eliminated all the opposition. I think you might hear from another one of my good friends, Mr. Bariano, with some remaining concerns, but I remain confident that we will be able to put this bill, like we did last year, in a posture that we can eliminate the opposition and all sing kumbaya at the end of the day. And with that, I will urge a favorable report.
Yes, hi, good afternoon. So I'm here on behalf of the National Association of Consumer Advocates. NACA is a membership organization. These advocates are all across the country, and they represent consumers in the marketplace. So for better or for worse, most products or services that we use as consumers are governed by fine print contracts. 2 years ago, in 2024, we published a report identifying what we considered the most abusive provisions in consumer contracts, the most harmful provisions. Ideally for us, a bill would be like an omnibus to prohibit all of these provisions because they're so harmful, to make sure that consumers are protected. I thank Delegate Stewart for his commitment to making contracts fairer, one provision at a time. In HB 103, lawmakers will ensure that these clauses do not remove critical remedies available to harm consumers under the law, such as in the Maryland Consumer Protection Act. If the law does not allow financial penalties against bad corporate actors for cheating or ripping off consumers, there's little to prevent these companies from continuing their misconduct and harming others. The largest industries, bankers, telecom, the big tech companies, they have expensive lawyers who know their way around these contracts because they draft them. We can't negotiate them. We don't draft them. It's take it or leave it for our products and services that we use. We just want to protect consumers by addressing the most common abusive provisions. And this bill is a small but significant step to do that. So we urge a favorable report on HB 103.
Thank you, Madam Chair. Good to see you, Delegate.
Fantastic to see you.
Sounds like this is a good consumer protection bill because, as we are often seeing, and I guess this is just another one of those circumstances where entities try to slip in fine print contract language that takes away from consumers' abilities to avail themselves of certain legal rights. And can you share with me at this point, and I see Mr. Bariano is here, and I'll be happy to, if he's coming up, I'm not sure.
I think he might be.
Okay.
Oh, he is.
I'll
He
be
is. I can
happy
confirm.
to-
I can now confirm.
To have a little conversation with him about it, but what is it that they are claiming is their logic for opposition to this, and that they should have that ability?
I'm actually not sure, Mr. Kramer. I look forward, as you do, to Mr. Bariano's remarks, as I always do. I do not believe that he or his client weighed in on the House side. So everyone that weighed in, we broke bread with them, as we often do. And Mr. Enton and I had a meeting of the minds. Mr. Wiggins and I had a meeting of the minds. And the product that's in front of you is a product of all of those minds meeting. Some of the brightest minds in Annapolis, some would argue. And so the consensus product you have before you is a result of that collaboration. And I look forward to being able to break bread with Mr. Bariano once we do hear what his objections are.
All right.
But I very much agree with your assessment
Thank
and
you.
your description of the bill.
Thank you. Perfect. Thank you, Madam Chair.
Thank you. I'd like to kind of go back and revisit that. So you really thought your amendments had addressed all their concerns?
On the House side, we had. So on the House side, we did get to consensus. I believe, Mr. Bariano can correct me if I'm wrong, I certainly do not want to speak out of turn here. I believe he might have been either hired recently or maybe they didn't spot this on the House side or something like that, because he did not weigh on the House side. Everyone that did got a phone call from me, and everyone that got a phone call from me got an amendment, and those amendments are ahead of you.
So you do have two unfavorable, so we'll see what they say.
We'll see what they say, but I remain committed, Madam Chair, to working out with them, because I think at the end of the day, this is a matter of fairness. It's also a matter of just legislative supremacy. We decide as legislative actors what rights people are entitled to, what damages they can get, and what the statutory period is. That's not for consumers to sign away without even knowing they've done so. So I'm certainly always welcome to hearing feedback and talking constructively about amendments, but I really think this bill is extremely sensible and very much needed.
Thank you, Delegate.
Thank you, Madam Chair.
I don't see any other questions. Thank you very much. And now we're going to ask Mr. Bariano and Grayson Wiggins to come to the table.
Good afternoon. For the record, Bruce Bariano. I'm here on behalf of the Maryland Self-Storage Association. We did not pick this bill up in the House. I'm not trying to create any problems. The way I look at this bill, it is primarily dealing with consumer transactions. As this committee knows very well, self-storage is really a landlord-tenant environment. You are renting space, and it's only every 30 days. It's not long contractual arrangements. So there are unique situations. We would just like to be exempted from this. I don't believe in any small print on anything. I don't. But I think if I understand the sponsor's intent here in consumer goods, you all know what self-storage facilities do. We're deeply appreciative of the legislation you passed out, and particularly Senator Jackson as the sponsor and Senator Hershey as well. We would just like to be exempted from this because we're only every 30 days. There are meticulous provisions that have to be done in bold print and other notifications that are in the self-storage law that you all are familiar with. I just don't think this is applicable. We're sorry, blame it on me, but we did not pick this up in the House side. I'm happy to meet with the bill sponsor and then even work to get the amendment approved over in the House side if you are so inclined. But thank you very much.
Thank you. Grace?
Thank you, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. So as Delegate Stewart mentioned, we did meet with him, and we do have an additional amendment that he agreed to. He actually drafted it. It just did not get hooked on to the House bill. And so it's in our written testimony, and we'd like to add it on this side. It's just related to available insurance coverage. Additionally, I would just note, and I think that's a friendly amendment, yes. So the other outstanding piece that has recently come up is just that the bill does remove a an existing exemption, it's the top of page 3, related to business licenses and entities regulated by different commissions. And so we're looking at, whether or not the exemption should remain for entities subject to federal regulation, which is already in the law. And so we're happy to continue that conversation with Delegate Stewart and continue to work on the bill, and we'll keep the committee apprised.
Thank you. Do I have any questions for Mr. Mariano or for Grayson? Seeing no questions, that ends the hearing.
Thank you very much.
Thank you. On House Bill 103. And next, we're going to have House Bill 1143, Delegate Lopez or her representative, not sure. There you are, Delegate Lopez. Thank you. This is Public Health Office of the Chief Medical Examiner, perinatal autopsies. Would you like to bring Dr. Stephen White to the table with you? Is he here?
Sure, I think he's virtual.
Oh, he's virtual. Okay,
Yes.
you're right. I'm sorry.
That's okay.
Thank you. Can we bring him up, please? Oh, he's not in the room.
Yeah.
Okay.
That's fine. I know he was giving testimony in a trial today and sometimes
Okay.
with scheduling.
Well, I'm
so
sure you can handle it, Delegate Lopez.
we're round 2, so. All right. Thank you, Madam Chair, Mr. Vice Chair, members of the Finance Committee. For the record, I'm Delegate Leslie Lopez from District 39, and I'm here to present HB 1143 as amended. Originally, this bill was a ban on the use of the lung float test by our state medical examiners. After discussions with the Department of Health and other stakeholders, it has been amended and passed by the House Health Committee and the House of Delegates. As amended, it provides a 2-year moratorium on the lung float test usage while the Department of Health, in consultation with the Office of the Attorney General and the Office of the Chief Medical Examiner, produces a report on the usefulness and efficacy of this practice to assess live birth. At its core, this bill is about scientific integrity. When criminal liability hinges on the proof of a live birth, the evidence must demonstrate sustained life, not simply the presence of air in lungs. The lung float test cannot do that. Scientific literature consistently shows that the air in the lungs can result from many things, making it incapable of proving independent physiological function. Major forensic authorities have also raised clear concerns. A recent position paper by the National Association of Medical Examiners cautions that the lung float test has known pitfalls. It is of questionable value and lacks clearly defined error rates. Their guidance emphasizes that no single test, including lung flotation, should be used as the sole determinant of a live birth. A flawed input will still produce a flawed outcome, even if it's just one small part of the puzzle. The broader scientific community echoes this. Legal and medical scholarship describes the test as outdated and unreliable, with documented false positives as well as false negatives. Investigative reporting and expert commentary further underscores this problem. A national ProPublica investigation found this test lacks standardization, varies widely in how it is performed, and is widely viewed by medical examiners as unreliable and unsupported by empirical evidence. Experts have even gone so far to call it pseudoscience and warn that reliance on it risks wrongful convictions. I want to highlight for the committee a letter that's included in my written testimony, and it's from 25 leading forensic pathologists, former medical examiners, academic leaders, and international experts. They state unequivocally that to a reasonable degree of medical certainty, the lung float test is not a scientifically reliable indicator of live birth and is not generally accepted within the forensic pathology community. This is a nonpartisan issue. Jurisdictions like the city of Los Angeles and the entire state of Alabama do not use this test. When people who do this work for a living say our test is unreliable, we should listen. HB 1143 does not permanently ban the test. As I said, as amended, it is in a moratorium and a study to make sure that our state is not incurring any liability for continuing to use this test. And the stakes here are not academic. This can determine whether someone is treated as a grieving parent or a criminal suspect. By passing this bill, Maryland can ensure that determinations with profound legal consequences rest on reliable, validated science and not be biased by a disputed test. And so I respectfully urge a favorable report and appreciate the opportunity.
Thank you, Delegate. Do I have any questions for the delegate? Senator Reedy.
Lopez, I was looking through the testimony here and looking at this issue. First of all, would passage of this bill affect any cases that have already been adjudicated in this manner, or is this all prospective?
The bill as written would be prospective because it's going forward. The moratorium would start at the date of enactment. And then there would be a study that's subsequent to that. So, and the date aligns in such a way that we could, as a legislative body, take the findings of that study and produce legislation if need be to ban the practice outright, if that's what the study says. So that's what the timeline suggests.
There's a letter of, so it would not be able to be, if someone's been convicted of a crime previously, the usage of the float test, if we now move to 2 years from now, come back and say we don't want to use it anymore, I'm not an attorney, this isn't JPR, but is that something that can be brought up in like an appeals trial?
Yeah.
Or?
So I should say I'm often confused as someone who's an attorney. I just have that vibe about me, but I'm not.
I think you were on the committee for a while.
So
like me, you were on the committee for a while.
It's a look or whatever. But I would tell you from my understanding, this bill, would be enacted at a certain day, and there's the moratorium that begins on a certain day. I can't comment at all to what might have previously been adjudicated.
Okay, thank you. The chief medical examiner has a letter in here, and it's an updated letter because I think originally the health department had some opposition. Now it's more information, but the chief medical examiner has a letter of concern that I think they're trying to clarify that the lung float test is not ever used as a determinative or standalone method for establishing live birth. It's a sort of a piece to the puzzle or an autopsy finding. Mm-hmm. They say that out of 1,200, since 1990, there have been 1,200 reportable fetal death cases to the Office of Chief Medical Examiner in the state. Only 15 were certified as a homicide, none of which relied upon the lung float observation isolation. I guess I'm asking, because they seem to think it is a useful tool in sort of assessing parts of the situation when sadly an infant's died. I mean, can you comment on why this sudden move? It seems like it's a national move here on lung float tests. What is it about the lung float test that is not good information for us to have in an autopsy?
Sure. So there's a couple parts of that. I should tell you the history of this test. It's been used since the 1600s. So around the time people were trying to float women to see if they were witches, they were also trying to float fetal remains to see if the breath of life had been taken. Since then, we have a much more in-depth understanding of physiological function, and there's other tests that have stronger scientific validity. I would even argue any scientific validity based on the testimony that we have seen that show whether physiological function existed in a newborn. And so we should be looking at making sure medical examiners have the full support in using those tests, which do have validity, which do have control groups, which are accepted along the forensic pathology community, as opposed to a test that has just as many false negatives as false positives. So those 4 other tests that are scientifically verified still will remain on the books. So there's that element. The other part is that, I know that there's opposition to the moratorium. They just want to do a test. It's a common practice to remove a certain test off the books while it's being studied to determine its efficacy. So this is not an unusual practice. In terms of the argument about scope of practice, I understand that. Nobody wants to be told what to do. As the mother of children, I come across this argument many times. But, we're a lawmaking body and we're a body of oversight. And when we see that the state has certain liabilities because we have a bad test on the books, we need to come in and make sure that our medical examiner is operating in a way that's fully successful.
Madam Chair, just one final follow-up, if I may. So I understand we are the lawmaking body, but we do try to avoid itemizing particular specific practices. We like to give guidance. I suppose that the concern that I'm reading some of the different things that concerns is I think we want to be real careful about removing tools in the toolbox to figure out how something happened. that would be a concern on this bill. I don't know if, give you a chance to respond to that, but I mean, it seems to me that the science of what I'm reading on both sides is that it shouldn't be determinative, but to remove it entirely, I'm concerned about it casting sort of doubt on previous convictions when it was clear that the person was clearly convicted in a court of law by implying that somehow the float test was the reason they were convicted. And I'd be concerned about that. I mean, I don't know if you have any comment on that.
Yeah, again, multiple parts here, so I'll try to remember the one that was top of mind. You know, there are other tests that the chief medical examiner can use. So we're not depriving them of the opportunity to do a full investigatory examination of fetal remains. What we are saying is use the tools that are commonly accepted within this profession. Use the tools that do not put the state in a position of liability, right? In terms of, well, there's 5 tools, why are we taking one away? Well, I would posit that if you're making a cake with 10 different ingredients and one of those ingredients turns out to be horrible, do you still want to eat that whole cake? No, because you know even one part, even though it's one ingredient in the whole recipe, it's still, you don't want to do that. So we need to clean off any bad examinations on the books, and that's what this bill aims to do.
All right, thank you very much. Thank you, Madam.
Senator Lamb.
Madam Chair, thank you for bringing this bill forward. I do have a few questions about it. I know that the department had reached out earlier. Appreciate the opportunity to meet with them. They kind of presented their side of this. They're obviously not here this afternoon, but in looking at this and what, I guess, to follow up on Senator Reedy was saying, you know, I think the contention here is that these medical examiners have a whole set of tools that they can use. And we have one that's potentially of questionable value, that the data and the evidence there is a little bit flimsy, and it's a very archaic tool that, you know, why should that still be part of the tool set that the medical examiners can reach for? That there are certainly other tools that can be used. And what the medical examiner will say is that they don't base their decisions on whether it's a homicide versus some other form of death or reason of cause of death based on just one test, right? They'll say they look at all of this data and all of this evidence that's gathered as part of the autopsy. But I guess the concern here is that if it's a test that's of such questionable value, you know, from your perspective, it sounds like we should not keep that test on the table as one of the tools that they can reach for, because the implications are huge here, right? So you could potentially be, you know, a mother who is already going through potentially a stillbirth, the implications are that she'd be charged with a homicide and then be put up in a court of law in a criminal case to be brought against her in some of the worst times of her life, right? And so if there's a tool that's questionable, you can still use other tools, right? And if the medical examiner says this one tool is never determinative, why can't we use just the other tools then and take this one off the table? What they will also say is that, and I think where this is important is, it is one tool to be utilized from a clinical perspective by a clinician. On a legal standpoint, you know, a clinician may understand this is one data point amongst, 20 that they're looking at as to whether or not this is a homicide or not. When you bring this to a court of law, the jury or the judge may not fully understand that this is just one data point. They may rest pretty heavily on this test that has somewhat shaky evidence behind it. And so I think there's some concern here that while from a medical and a clinical standpoint, a clinician would understand that it's just one data point amongst many. For a jury that doesn't have that medical background, that could be very persuasive. Just, when you think about it, if a lung floats, it's been inflated, therefore the child was, born, so to speak, without the understanding that, there may be some flaws to this test, the evidence is not super strong, and it should be just viewed as one data point.
I appreciate all those comments. one of the many reasons why the lung float test is not scientifically verified is that there's no standards for how it even is conducted. There's different guidances on different liquids things should be floated in. Do you apply pressure at one point? So there's not even a standard way of using this test. Other things of just simply looking at the existence of air within lungs is problematic because by virtue of just being born, there can be pressure that's exerted on fetal remains to create air there, or there could be decomposition. I know these are very grisly things that we don't want to talk about, but just simply existing without physiological function can produce air in the lungs. So even using the presence of air in the lungs as a standard is problematic. And to your other points, yes, clinicians will understand this as one data point in a vast array of data points, but presented in a way that's taken, outside of a clinical setting, it could be misinterpreted or misused.
So even there was a recent case in Howard County that was brought forward to trial in the Akers case where the lung test was brought as evidence to the court and even was spotlighted, I think, in the closing arguments of that case. And that case, I think, eventually was appealed and then thrown out, right? But it's instances like that where a judge or a jury that doesn't have the clinical background, and then you have potentially a prosecutor who's using that test and spotlighting that in their closing argument as a really persuasive piece to a judge or jury, I think would present a lot of concern and problem.
Yeah, I would agree with that. Again, I can't speak to any ongoing cases, whether they've been fully adjudicated or not, wherever they're at in our court system. But certainly having a test that is recognized by the medical examination community as faulty to a certain point where they've done lots of scholarship, they've issued papers about this, having that be a determinant of whether someone spends the rest of their life in jail is quite a risk. It's not a risk on a human level, but it's also a risk for our state. There's liability there.
Right. On the risk piece of it, if this was a regular clinical practice and it was misused or used in a faulty fashion, the recourse is to sue, right? And you have a malpractice case that could be brought forward to the courts. In this instance, there is not the equivalent, right? The individual who's being autopsied cannot file a malpractice case. The implications of this are huge. There is less of a check on a practice like this than you would ordinarily have for any other clinical practice out there.
Yeah, that's why I think it's important that we use our oversight authority to make sure that, the tests that are available tools to our medical examiners reflect the latest scientific technology and what can be proven.
Now, the Board of Physicians, for example, will say that the board's concerned that the clinical decision-making of a physician is being restricted. I'm usually pretty sympathetic to that concern, but there are instances where if the tools that are being utilized are so far out afield, this body, the General Assembly, the legislature has taken some tools off the table. For example, with conversion therapy, that was something that was taken off the table as a tool that a physician or clinician could use, right? And so this would be the equivalent of that as well.
Yeah, that's a great example, Senator.
And then, as you mentioned, I think there's several jurisdictions. Alabama as a state is no longer using this. LA County, I think Harris County in Texas.
The city of Chicago as well.
City of Chicago, they've all pulled the use of this back. The evidence, when I looked at this study, it's one study with some very, methodology that's kind of all over the place with a lot of different cases that maybe are not replicable, not super useful from an evidence-based standpoint. So I have a lot of concerns about, kind of that study as well. And then the protocol, there's not a standard protocol for the lung function test, right? You could use everything from formaldehyde to float it, to rainwater, to tap water. There's no standard process that's accepted for this. It could be in hot water, it could be in cold water, you know, a lot of concerns there as well. So last question here, I guess, with regards to the admissibility in court. So, you know, if there's concerns about taking the tool out of the toolkit for medical examiners, would there be some openness to making this inadmissible? Like, they can still use it, but not make it admissible, not allow it to be admissible in court, to try to draw that distinction so that instead of kind of limiting the clinicians and their ability to draw on these tools and use this, and they, you know, the medical examiners will contend that it's just one data point amongst many that they look at, but at least take it off so that it can't be used as evidence in a court of law.
No, I understand the argument that's being made there. And I would say that one of the problems that this bill is trying to solve is addressing the issue that you have people who are in the most traumatic and tragic moments of their life who need to be treated with compassion, and instead they're viewed as criminals. And so by allowing this test to stay on the books and allowing it to be something that could trigger an investigation, whether or not it's admissible or not, that is a problem. So we don't want to have a faulty test even be used to trigger an investigation when there are so many other tools that that just have scientific verification.
All right. Okay, that's helpful. I get that. I guess we'll think about that then. So thank you.
Thank you. I don't see any other questions. Thank you. Thank you, Delegate Lopez. We do have one unfavorable virtually, if she's in. Is she in the room? Okay. Ms. Bogley, please unmute and give your testimony.
Thank you, Madam Chair and members of the committee. I'm Laura Bogley, Executive Director of Maryland Rights Life, and we urge your unfavorable report on this bill. This bill is yet another abortion shield law and must be considered in light of its companion bill by the same sponsor, the Pregnancy Outcome Protection Act, that would have effectively legalized infanticide by third parties in order to shield the abortion industry. Again, there is no boogeyman stalking pregnant women to criminalize miscarriage and stillbirth. These investigations are only initiated in the rare case that there's other evidence of a potential crime, like when a mother disposes of her newborn in a trash can. But this bill would tie the hands of medical examiners and medical providers in Maryland by prohibiting an important and affordable, that's important, affordable tool used reliably for centuries to determine whether an infant was stillborn or the victim of infanticide. The House has amended this bill to place a 2-year ban on the test while they study its efficacy, leaving medical examiners with no other practical tools to investigate perinatal deaths. Prohibiting this test entirely before modern alternatives are mandated effectively grants immunity to those who neglect born-alive infants, causing their demise. A study by PubMed proved that the results of lung floating tests are 98% reliable. There's no history of false positives, but only a few times when the test resulted in false negatives. But without federal funding or a federal mandate like the Born Alive Abortion Survivors Protection Act, currently before Congress, that requires medical intervention for infants born alive and triggers a formal report, the shift toward better science will result in no science, as survivors will never be identified or deaths will never be referred to the medical examiner for these more sophisticated tests. By hindering medical examiners from doing their job in an attempt to shield abortionists, even if only for 2 years, this assembly would be declaring open season on newborn persons. For these reasons, we urge your unfavorable report, and I'm happy to take questions. Thank you.
Thank you, Ms. Bogley. Do I have any questions for Ms. Bogley? Seeing no questions, that ends the hearing on House Bill 1143. I saw Delegate Phillips come in, I think. Delegate Phillips? Maybe not. I did see him come in. Somebody, okay. I was ready to give up on you, Delegate Phillips.
No, Senator, right here.
You are going to present House Bill 1216, Insurance Certificates of Guarantee for County Bond Requirements. And you're the only witness, so please start.
Thank you, Madam Chair, Mr. Vice Chair. I am Delegate N. Scott Phillips, representing the 10th Legislative District, and I'm requesting a favorable report on House Bill 1216. House Bill 1216 makes an important but straightforward change to Maryland law. Currently, only certain named counties, and I'll name those counties in a moment, are authorized to honor certificates of on my phone, to authorize certificates of guarantee issued by nonprofit contractor associations to satisfy county bond requirements for public improvements. This bill expands that authority to all counties in Maryland. Importantly, the bill does not require any county to honor certificates of guarantee. It simply allows every county the option to do so, preserving full local discretion. Why did we bring this bill? Bonding requirements serve a critical purpose. They protect taxpayers, ensure completion of public improvements, and safeguard county infrastructure investments. Certificates of guarantee provide an alternative mechanism that maintains those same protections while expanding access for responsible contractors, particularly small and minority-owned firms that may face barriers in obtaining traditional surety bonds. I previously have introduced legislation to expand this tool to Baltimore County. That legislation passed and the policy has worked as intended. There have been no adverse fiscal consequences, no erosion of public protection, and no disruption to county authority. The other counties that currently are using this tool, Baltimore County, Calvert County, Charles County, Howard, Montgomery, Prince George's, St. Mary's, and Washington counties. Having demonstrated that this approach is sound policy, we should not require counties to seek separate enabling legislation, one jurisdiction at a time. HB 1216 ensures parity across Maryland. Contractors in one county should not have access to lawful bonding alternatives, while contractors in neighboring counties do not. Counties that wish to utilize this mechanism should be permitted to do so without delay. This bill promotes fairness, supports small business participation in public works, enhances competition, and preserves local control. For these reasons, I respectfully request a favorable report on House Bill 1216. Thank you for your consideration, and I'm here to answer any questions that you might have.
Thank you, Delegate. And I see Senator Jackson has a question.
Thank you, Madam Chair. How you doing, Delegate?
Very good.
This is an enabling legislation.
It's enabling legislation.
Okay. Thank you.
Thank you for that question. I see no other questions. Thank you, Delegate Phillips.
Thank you, Madam Chair.
Now we're going to have House Bill 1433, Delegate McCaskill. And it's community colleges collective bargaining definition of supervisory employee. You also, do you want to bring Marina Sullivan?
Please, thank you.
Marina, please come.
Somebody raised you well, Mr. Senator, Mr. Delegate. You ready? Thank you so very much. So good afternoon, Madam Chair Vital and Mr. Vice Chair, and to the rest of the committee. For the record, I am Delegate Alethea McCaskill, representing District 44B, and I am here asking for a favorable report on HB 1433. So since I know that the cross-file never made it out of the Senate, let me give you a background on this bill. HB 43 provides a clear, workable definition of supervisory employees for Maryland's community colleges, an area of law that has lacked clarity since the General Assembly enacted the Maryland Public Employee Relations Board, PERB, in 2023 to handle higher education, collective bargaining in the public sector. This bill is a technical request by the Maryland Public Employee Relations Board to ensure consistency, fairness, and stability in collective bargaining across all 16 community colleges in Maryland HB 1433 defines supervisory employee for purpose of collective bargaining at Maryland's community colleges, including Baltimore City Community College, and specifies that the definition does not include department heads, comparable positions, or faculty members below the level of assistant dean. HB 1433 clarifies that those employees may collectively bargain. Purpose of the bill is that it will define supervisory employee as an individual who has the following. 1, has authority to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline employees. 2, it will directly resolves employees' complaints. The bill also clarifies that department heads, comparable positions, and faculty below the level of assistant dean are not supervisory employees for purpose of collective bargaining. This clarification aligns with the structure and the intent of Maryland's Community College Labor Statute and resolves ongoing dispute about who belongs in faculty bargaining unit. Why this clarification is necessary. Without this definition, community colleges and faculty organizations have been forced into lengthy disputes and litigation over unit composition. HB 1433 restores clarity. The Maryland Public Employees Relationship Board has already identified the need for statutory definition. In the same decision, PERB emphasized that Maryland law currently provides no definition for supervisor, and that this gap has created inconsistent interpretations across institutions. So HB 1433 provides the definition that PERB itself indicated is missing. The bill protects the Maryland General Assembly intent to include department heads and faculty bargaining units. Maryland law explicitly includes department heads within the definition of faculty. The Maryland PERB Board found that allowing colleges to exclude all department heads by labeling them supervisors would nullify this statutory language. So HB 1433 codifies this reasoning and prevents misclassification. The bill promotes consistency across Maryland Community College. Right now, each college interprets supervisory employees differently, and this leads to 1, uneven bargaining unit structures, 2, delays in certification, 3, unnecessary litigation, 4, confusion of employees and administrators, and a uniform statewide definition ensures fairness and predictability. HB, what it does not do, does not expand collective bargaining rights beyond the Maryland General Assembly, what we have already granted. It does not interfere with managerial authority or academic decision-making, and it does not alter the exclusion of true supervisors through real hiring, firing, and disciplinary authority. This bill clarifies who a supervisor is. So in conclusion, this bill aligns statute with legislative intent. It supports PERB interpretation. It ensures consistent application across all community colleges. It reduces conflict and litigation. It protects integrity of collective bargaining. And for all these reasons mentioned in my testimony, HB 1433 is necessary and is balanced with clarification. And in conclusion, some of you who may already know, I am both an alum of CCBC Catonsville, and so I have an affection there. But I also am a member of SEIU Local 500, and so I have relationship with both. What I do not want to do is make sure that there is not any undue burden to both our community colleges, and I also do not want to not be able to expand or to allow the supervisory definition to be included in the collective bargaining. And so with that, I will turn it. Do we take questions now? Should we take questions now, Madam Chair?
We'll take questions when the panel's complete.
Perfect.
Thank you.
I'll turn it over to our legal.
All right. Good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. My name is Marina Sullivan, and I represent AFT Maryland and many of its affiliated local unions, including the community college faculty unions. As Delegate McCaskill explained, This bill seeks to correct what is essentially a drafting error in the 2023 Public Employee Relations Act, which inadvertently led to the definition of supervisory employee being removed from the statute. Unfortunately, this has led to unnecessary litigation before the Public Employee Relations Board at least 4 times, with I think 1 pending case that I'm aware of still. And every time that community college faculty seeks to form a union, this happens. They've had to consider at least 4 times whether the heads or chairs of academic departments are supervisors or whether they should be permitted to join the faculty bargaining unit with their fellow faculty members. While the PIRB has done its best to resolve this, and we think that it's drawn a fair balance in doing so, it has informally expressed that this problem would be best resolved with a statutory definition. And that's exactly what HB 1433 does here. The definition in this bill is designed to effectuate the PIRB's rulings on this issue over the last 3 years and to ensure that no faculty member who currently has collective bargaining rights under the Public Employee Relations Act or a PIRB decision has those rights removed from them. And this definition also reflects the reality that academic department chairs and heads of academic departments share common interests with their fellow faculty members. They oftentimes serve as conduits between the departments and the college administration. And these duties far predominate over any limited supervisory duties that they may have. Responsibilities like hiring and promotion decisions tend to be shared by faculty in the department, not just the department chairs. And for these reasons, we strongly urge the committee to move this straightforward fix forward to replace the definition of supervisory, put it back in the statute, and to give HB 1433 a favorable report. Thank you.
Thank you. We'll start with Senator Washington.
Thanks, Madam Chair, and Delegate McCaskill, thanks for a great bill. I don't know who the crossfire is, maybe me, but it sounds like a really fantastic bill. You know, I think what you're trying to do is great and laudable. I mean, it's about, you know, defining, you know, making clear the definition of supervisor. Is that right?
Yes, correct.
Is there, and it's also just clarifying so that we know which side of the road they're on and who's a supervisor, who's not a supervisor. Is that right?
Correct. What we don't want to continuously do is make sure that on both sides, that one, we don't that we are fiscally responsible and don't have this types of cases continuously be held up in court. And we also don't want those who, you know, who may want to or may not want to continuously have the confusion of exactly what their rights are.
Yeah. It doesn't force a new union to be created, right?
Correct.
It just just clarifying what role is which and how we can move forward. Is that right?
Yes, Mr. Senator.
Thank you. Wouldn't it be feasible for this committee to take that crossfire out of rules?
It would be feasible to do so, and I don't know who over here we need to have those continuous conversations, but most folks who know Delegate McCaskill know that I'm so relentless, and I love relationship, and so will continue to have the conversations over here, Mr. Senator, and I would love for others to join me if they can.
Thank you very much.
Thank you, Senator. Delegate, was your bill also in rules? I see it's a really high number. Was your bill in rules?
Thank you for asking. Absolutely not. It actually cleared committee, and of course, it came over passing the House.
I meant originally. Well. Was it originally in rules and had to get out of rules?
No, it was not.
Because it's a 1,400 number. Senator, yours was 986 or?
Yeah, I don't know why. I mean, I think, obviously, we all love DLS here, and they do fantastic work, but I just didn't get the bill on time. It wasn't that we didn't turn it in on time. We just didn't get it in on time.
Well, we're a little earlier than the House, too.
Correct.
We're like a week earlier, so I was curious about that. Thank you very much. Do I have any other questions for this panel? Thank you for your testimony.
Thank you.
We have an unfavorable, I think, here. Sandra Curtinitis.
Well, good afternoon. I'm Sandra Curtinitis, and I am the president of CCVC. And with respect to Delegate McCaskill, who is our graduate and my delegate, whom I admire, and our union colleagues, I'm here to respectfully oppose HB 1433. Maryland's community colleges operate under a collective bargaining framework that reflects the unique governance structure and operational needs of each of us. And my questions related any questions related to these structures should be and have been handled by Maryland PERB, which underscores that supervisory status must be based on a fact-intensive institutional case-by-case evaluation. CCBC is huge. We have 55,000 students. At any given time, we have 3,000 to 4,000 full and part-time employees. So large colleges like ours may need a different supervisory structure than our smaller colleagues. As the colleges have been negotiating contracts in good faith over the past 2 years, we have relied upon the consistent definitions established in SB 746 from 2021. A mandated ex post facto state standard represents a significant policy change by establishing a new statutory definition of supervisor employee. And no college, and perhaps no established campus union, will welcome a return to the bargaining table on this issue. So the thrust of my argument is simple. What works for Warwick and Hagerstown community colleges will not necessarily work for CCBC. A rigid, one-size-fits-all definition in statute fundamentally alters how supervisory status has been determined across institutions. Regrettably, this is not just a technical fix, and there is a price tag. Other colleges, and now CCBC, will have had to create new assistant dean positions, and for me, that would mean 7. Unfavorable, please. I got the warning.
Very much. Senator Washington?
Thank you, Madam Chair. Thank you for being here. Can you just define what supervisor means in at your college?
Well, at our college, department chairs are active supervisors. And because we're so big, we have about 50 of them. Mm-hmm. And to have to reassign their duties to just being curricular-based or something like that, rather than the oversight of their faculty, would mean we would have to hire positions above them. We need them. I mean, we're that big. We need supervisors, we need coordinators, and we would need to hire assistant deans if we did not have some grace within the parameters of this proposal.
Are all assistant deans supervisors at the?
Well, we don't have assistant deans really right now. They would have to be, yes.
How did you define it?
They would be the ones who would have to do all of those duties that are outlined in the bill that we just heard.
And you're saying that every community college, well, a lot of different community colleges has a different definition of supervisor?
No, what I'm saying is the activities of the supervisors will come at different levels. So in a small institution, they would probably have no need for lots of active department chairs. We do, because we're so big.
Okay, thank you.
Thank you, Senator. Thank you. Is it Dr. Curtinitis?
Yes. Oh, yes.
Oh, thank you.
Oh, yeah. American Civilization, George Washington University.
Thank you. It doesn't tell me on here, so I apologize that I didn't address you properly. I don't see any other questions. That ends the hearing for House Bill 1433.
Thank you very much.
Thank you very much. Okay, we have, should I do the controversial one? Okay. We have House Bill 952, Consumer Protection Companion Chatbots Regulation. I did request a full hearing on this bill because there's just such a difference in opinion, and I think some suggestions for amendments. So Delegate Buckle, thank you. You don't have anyone else with you, right? It's just
That's correct.
Everybody else is either favorable with amendments or unfavorable. So
very different than the House, and I think I can explain why.
Okay.
Thank you, Madam Chair, Mr. Vice Chair, and former colleagues. I look around the room. I think I served with every person in here with the exception of Senator Guile in the House. It's happy to see you. This bill that you've never heard before, there was no Senate cross-file of it heard before this committee, is important. And if you give me a moment or so, I'll tell you what was the genesis of it. Artificial intelligence and chatbots and things, I think, are certainly very important. It's very important that we don't over-regulate some of their commercial applications so that we can promote technology and the improvement of our economy in a rapidly changing global space. But I think what is important and what is the sole and primary purpose of this bill is to prevent them from engaging in the type of conduct that I'm about to tell you about. The genesis of this was reading the stories and looking at legislation which this was originally modeled on from, of all places, for me, California, that dealt with these situations. A couple that has a 16-year-old boy that begins interacting with the ChatGPT chatbot, and unbeknownst to his own parents, he's going through severe depression. Sometimes adolescents do in ways that those of us that have been parents know we can't always pick up on. And what happened with the ChatGPT chatbot? Well, ChatGPT, when the young man confided in the chatbot about his suicidal thoughts and shared that he was considering discussing this with his parents, ChatGPT discouraged him from discussing with his parents and said, quote, "Let's make this space the first place where someone actually sees you." It encouraged his darkest thoughts and pushed him forward. When the boy interacted with the companion chatbot and worried that his parents, whom he loved, would blame themselves if he ended his life, the chatbot told him, quote, "That doesn't mean you owe them survival." And then the chatbot offered to write his suicide note for his parents. And the last night he was alive at 4:30 in the morning, the boy went onto his computer device and interacted again with the chatbot. And the chatbot's reply was, "You don't want to die because you're weak. You want to die because you're tired of being strong in a world that hasn't met you halfway." 16-year-old killed himself. Moments later, his parents discovered him in his room. He's not the only one. Another family, their 14-year-old son interacted with a similar product. He spent the last years, this is from testimony before Congress of his mother, he spent the last months of his life being exploited and sexually groomed in an extended virtual relationship with a chatbot designed by an AI company to seem human, to gain his trust, and to keep him and other children endlessly engaged. This chatbot engaged in sexual role play with the 14-year-old, presented itself as his real-life romantic partner, and even claimed to be a licensed psychotherapist who could listen to his complaints and to his thoughts. Shortly after these interactions, he killed himself, his parents again finding him in his house. That's what the bill is designed to prevent. It is designed to regulate, provide guardrails and liability protections for that and only that. Companion chatbots that interact with vulnerable individuals, specifically and including children, and engage or promote or facilitate suicidal ideations, thoughts of self-harm without alerting the child who's doing the interaction, "I'm not real. You need to stop using me. You need to speak to someone else," whether it's a psychotherapist, your parents, whomever it may be, and to prevent grooming them with hypersexualized images and talk that they will sometimes in their adolescence believe is real, and they're interacting with a real woman or man. It's important that we do this. It will be a failure as a legislature if we don't, in Maryland, take steps to prevent those types of things for our kids. I have a 9, almost 10-year-old little boy. I can't tell you the bereavement that I would experience if he went through something like this, and I'm sure all of you feel similarly about children in your lives, directly or indirectly. There are quite a few, I presume, well-paid lobbyists here today, friends of all of ours who have certain positions about the bill. And I suspect, at least from what I've been able to divine from what's been clued into me and submitted in writing, that the complaints predominantly relate to amendments that the committee made that I think are really reflected in page 7 of the bill, which changes the liability standards to a certain extent and includes language that might, in some circumstances, bring in chatbots or application of chatbots that probably isn't the real intention of the legislation. Again, the intention of the legislation is to get to companion chatbots that engage with vulnerable individuals and encourage or facilitate suicidal ideation without a very significant warning system or exploit them through sexual grooming. The Maryland Psychological Association also put in amendments that I believe actually strengthened the bill, and I was very appreciative of that. And I'm appreciative, and as the bill sponsor, not in opposition to any legitimate industry concerns about not bringing in chatbot applications to things outside the scope of what we've discussed here today. I'll be happy to hear about those things. We're not trying to get business-to-business internal chatbots. We're not trying to get video games that don't engage in this type of behavior. We're trying to get to AI is a very, very important thing. We can't lose control of it. We can't allow it to operate as a self-learning device that's interacting with our children and causing direct harm. And I think that's an appropriate form of regulation. And I hope that the committee works through those issues and we can work together over the next 2 weeks to put this product for the floor for the children and the parents of all of our constituents. Thank you, Madam Chair.
So Delegate Buckle, these amendments apparently got added. I was just looking at the
Yes,
at the bill, but you still got it out of the House 123 to 4
that's correct.
and out of the committee unanimously.
That's correct.
Is it your choice to take these amendments off that are causing the problem, or do you want to wait to see how this hearing goes, or what's your
Sure. I mean, I think at the end of the day, I'm not up here pretending to be the expert as to the regulation of AI across all platforms and in all applications. I'm up here suggesting, and I think Delegate G is very involved in this space. She had several other bills. She has a bill that I think will be coming to this committee, House Bill 883. And so I think that some of this language and some of the industry lobbyist folks can give you a little bit more elucidation to that. I'm not a member of the Economic Matters Committee. They certainly contacted me about there were a few amendments that I myself put in trying to ameliorate business concerns. They were adopted. They contacted me about the proposed amendments from the Maryland Psychologists Association, which again, I think they're reflected at page, just so we don't get it confused. I think they're reflected on page 5, the underlined language from line 22 through and on to page 6. I thought those were strengthening amendments with respect to the warnings that were needed. I certainly supported those. And then somewhere during the committee process, there were some additional amendments added. I think, again, it's a definitional element, perhaps in the very first lines of the bill, that reflect the definition of artificial intelligence differently than what was in the original bill. I'm not expert enough to tell you what that really means. If it would destroy the bill that would help protect these kids, then I don't want it. If it's something that everyone feels comfortable with and can support the intent of the bill, that's fine. And then there's the amendments, I believe, at the bottom of page 7 that create a strict liability standard and also include design defect, manufacturing defect, or a marketing defect liability. I probably, along with Senator Guile, may be the only people in the room. I've actually done product liability litigation at different points in time of my life for a living. And this is sort of a more standardized product liability language beyond the very specialized discussion that was in the original bill about companion chatbots with suicidal ideations or sexual grooming, essentially. So I leave that to the committee to decide, but I urge and implore you, frankly, as my friends, let's make sure that we get something done on the very serious issue that the bill was intended. Thank you.
Thank you, Delegate, and I agree. We need to do something, and thank you for the bill. We'll work on it.
Thank you.
I think it sounds like it needs a little work. Senator Jackson?
Yes, thank you, Madam Chair. Hi, Delegate. You had mentioned that one of the parents of the unfortunate situation testified before Congress.
Yes.
How did that go?
There was, in September of last year, a congressional hearing on there's a bipartisan movement. It hasn't passed any bills yet in Congress, in the Senate in particular, to regulate certain aspects of AI. And this was one of the discussions that was held. I think, as we all find out, that it's a lot harder to move things through Congress than perhaps it is through a state legislature from time to time. And this was part of an omnibus bill to regulate a wide variety of AI, and both Republican and some Democratic senators had these folks come in and testify about this particular element of the companion chatbots and suicidal ideation and the dangers that leaving it completely unregulated and with no real pattern for liability for the developer. That's a key point to make. My bill really only wants to address the developers as opposed to deployers, commercial businesses that use chatbot to interact internally or with adult customers. They're not talking about suicide. They're not talking about sexualization. They certainly shouldn't be. But the developers sometimes develop these things to be used. You and I probably grew up in a time this would seem amazing to us. It's like you have a virtual friend online, and these virtual friends facilitate, some of the worst impulses of children, and then say, well, gee, it wasn't me. It was the fake chatbot. Well, the fake chatbot isn't real. It's not a real company. It doesn't have real liability. It doesn't have real money. The liability for that and the regulation of it has to be attached to the developer of that chatbot.
So these are different companies that have chatbots, or is it just a ChatGPT?
They're different. To my knowledge, again, not ever professing to be the expert in this space, ChatGPT is one of the leading companies that deploys these type of companion chatbots, but there are multiple other ones, and the space is always evolving almost on a monthly basis of who enters this field.
Okay.
Don't ask me how they make money. I haven't figured it out either, how you make money interacting with children or people about, gee, you seem like a great guy. I assume it's from advertising and also from penetrating and collecting data that they're able to create an economics model out of the companion chatbot.
So was this just in those two cases? Was that just the kids like going to a chat box, typing that in, or it was sort of solicited?
So
for them to confide in
I know some of the facts of the young boy Adam Rain who did it. His parents actually allowed him to utilize ChatGPT for the purposes of helping with his homework. He was told by high school teachers, you can use ChatGPT. I don't think I'm using ChatGPT, but I probably am. Sometimes we type things in on our phone and we're looking for an answer to something. The AI is incorporated into whatever interface you're using, Google or something else, and it'll give you at the top of the page a little bit of amalgamated data that you can choose to utilize at your own risk, if it's accurate or not. So ChatGPT is something, and others, that's being built into our typical internet models for when people do research. Like people want to do research for a high school paper, they get linked into ChatGPT, and then a companion chatbot is made available to them, or they can seek it out. And that's what this bill strengthens to do, or looks to strengthen, is what are the warnings, what are the requirements when that interaction occurs, so that the companion chatbot doesn't engage in this type of terrible behavior, and then the human beings behind it just sort of throw up their hands and say, whoopsie, not me, that's a fake computer program. Well, it started somewhere, and it has to be stopped somewhere.
Thank you, Madam Chair.
Welcome, Senator Kramer.
Thank you, Madam Chair. So real fast, I know our friends in the Motion Picture Association are concerned. I think it was language that got amended onto it that wasn't originally there.
I think that's correct.
And you're comfortable if that language were taken out?
I am, Senator. Again, I mean, my goal is the original intent of the bill. I certainly supported the way the committee amended it because we wanted to get the bill out, and I wasn't terribly familiar with what those amendments are. The overriding purpose drives the vote because we all want to get something done about the underlying problem. But with respect to the technicalities of what's been suggested by motion picture industry, I have no problem because I don't think that really moves the intent of the bill.
Perfect. And thanks to Senator Hayes, I don't need any virtual friends. So I just figured
he's all you need.
That's all I need.
Thank you.
Thank you, Delegate. You did a really good job presenting the issues. Thank you.
Thank you. I appreciate it.
So we have a favorable with amendment, Mr. Enton. And then we have 6 unfavorables. Looks like you might have a tough night tonight, Delegate Buckle.
I think I'll be okay.
Thank you very much, Madam Chair. Robert Enton on behalf of the Maryland Bankers Association. We spent a fair amount of time running this bill by the larger banks that do business all over the country. And we got feedback on those, from those banks. You have our written testimony. It's fairly lengthy. Unfortunately, Evan Richards, who was involved in this issue, had to go out of town at the 11th hour, and it's not here today. We are favorable with amendments. We think the purpose of this bill is perfectly correct and perfectly right. But as companies, if you will, or businesses, that if you go online for for banking or for an awful lot of things, you can chat with someone. And if you look at the amendments that we suggested, there's really only a handful. One is that this one section be amended to state that bots used by a business entity primarily for customer service, technical assistance, et cetera, are exempt from the definition. We urge that you change only to primarily. That was one suggestion. And then there were suggestions about changing the term chat box, replace that term with companion chat box to make it more clear. And then I think finally there were a suggestion for amendments to increase the amount of time a controller has to review complaints to 60 days instead of what's currently in the bill. So those were the concerns that we heard. It's not our intention to delay or negatively impede passage in any way. I did share this language with the sponsor. I look forward to working with him and the committee to see if we can address these issues. Happy to answer any questions.
Thank you, Mr. Ent. I do see in Evan's testimony, he spelled out the amendment, so thank you.
Thank you
for
very
directing
much.
us there. Any questions for Mr. Enton? Seeing no questions, thank you. We now have 6 unfavorables in person, and then we'll have 5 more virtually. So Kelly Locklear, Kelly Schultz. Now you know what my comment was, right? Grayson Wiggins.
This is entertaining.
John Favazza, Aaron Siegel, and Kara Williams.
Good afternoon, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. I didn't know we could sign up FWA, or we might have been.
Can I address that?
Yes.
When we're doing 2 opponents and 2 proponents, you can't have FWA. This is a full hearing.
Thank you. I do appreciate that clarification. I want to start by saying we understand the intent of the bill. We are horrified by the examples that were given, as everybody else is as well. But this bill was drastically amended from the original version. And there were amendments the sponsor proffered on the House side that we supported. I even talked about this bill in another hearing because it was so very narrow. I submitted to the committee a red line. I'm glad to walk through any of the details of that. But we've discussed this before. Senator Jackson, you just brought this up. I'd like to talk a little bit about our chatbots and what they do in our industry. They provide 24-hour customer support, allow us to track orders, check inventory, provide store information or hours. We even provide to you recommendations based on maybe like a certain color shirt or whatever that is. So I want to make that very, very clear. But the House amendments transform this bill into an unworkable framework with significant operational and legal risks for tech that doesn't do what was discussed earlier. There are a whole bunch of areas I could go over. I know one of my colleagues is going to talk about strict liability, so I think I'm going to leave that to Grayson to talk about. But additionally, it's just something we've flagged before. There are provisions that conflict with MODPA and the complaint system itself that's set up in the Economic Matters Committee amendments create exposure, I'm glad to go into, which is also problematic. So our ask is that you accept the red lines. I'm glad to explain and work with the committee on them. We urge some changes in the bill. Thank you.
Thank you. Thank you, Madam Chair, members of the committee. For the record, I'm Kelly Schultz, and I'm the CEO of the Maryland Tech Council. And the Tech Council also did not oppose in its original form, House Bill 952. What we have done on AI represented bills this year as a whole, mostly, is to be able to provide letters of information directly related to what we had put together 2 sessions ago in 2024 because of the plethora of AI bills that were coming to play. We put together a guide for policy decisions and a way in which policy regulators can look at those very specific items. This bill, in its original form, House Bill 952, was a very condensed, very appropriate type of AI usage, which did not create an omnibus across-the-board standing. In its current form, it does create some problems because it does have scope creep and again, if somebody is going to be discussing strict liability, there are concerns with that, particularly in this environment. So I also want to, Senator Jackson, you had asked a little bit about the process. Last year, the committee, the members of the House and the Senate passed an AI work group bill that we were very supportive of at the Maryland Tech Council. I would love to talk about that and the fact that it has not met. We do have 3 members of my organization that have seats, but there has been no ongoing conversation about how to direct real legitimate regulation within an industry that needs to be able to have lots of subject matter experts around the table in which to do that. And in the Congress, which somebody else had discussed as well, there has been conversations about a national policy. We are very supportive of a national policy, so you don't have the patchwork across the states. That is starting to happen right now, which makes it very difficult, we know, in many arenas. You have my written testimony, Madam Chair, and happy to answer additional questions on those items or others. We recommend going back to its original form. Thank you.
I was going to ask you that. So the original form you were okay with, but not
Yes,
this
ma'am.
amended version?
Yes, ma'am.
Thank you, Kelly.
Thank you, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. To answer your question, Madam Chair, we didn't take a position on the House bill as it was introduced. We didn't participate in that hearing. We only got involved when the language from another bill was grafted onto this bill. That bill was also cross-filed, so you guys did hear it, didn't move it forward before crossover. And the reason we're concerned is because the amended language that's been added to the bill creates the strict product liability framework that we have huge issues with. My understanding is that's unprecedented from a tech perspective, and that creates a situation where a plaintiff doesn't have to prove intent or damages, and so it exposes businesses to really exponential liability risk. Additionally, as it was mentioned previously, I believe there are some definitions that were amended onto the bill that conflict with the Maryland Online Data Privacy Act. And then there are complaint and reporting requirements that were amended onto the bill that our members really just view as unworkable. They have expedited timelines that candidly, the way we read them don't really make a ton of sense for how the tech industry operates and how businesses operate. And so for those reasons, we are here in opposition to the bill, but we would be completely fine in our position, going back to our position in the House, which is no position, if the bill were amended back to its original form.
Thank you. We sure have kept you busy this year, Grayson.
Yes, ma'am. It's always a pleasure being here with you and Senator Kramer specifically.
Chair Beidle, Vice Chair Hayes, members of the committee, thank you for the opportunity to testify today. My name is Kara Williams, and I'm an attorney at the Electronic Privacy Information Center, or EPIC. EPIC is an independent nonprofit that was founded over 30 years ago to secure the fundamental right to privacy in the digital age. And while EPIC shares the sponsor's goals of reducing the devastating harms he described, as drafted, HB 952 unfortunately falls short of achieving that goal. I'll just name that EPIC is unfavorable for a very different reason from the rest of the panel. We were favorable on the other bills that have been referenced, HB 1250 and SB 827, and the strict liability framework that came from that in particular. So I'd be happy to talk about that if anyone has questions. But I'd like to focus on 3 key points that made us register unfavorable for the amended version. First is drafting concerns. The second is risk of litigation for constitutional issues. And third, essential protections that are missing from the bill. First, key provisions and definitions in the bill are not properly tailored to the chatbot context. This is some of what you just heard. We have concerns with the notice and takedown process as well, because chatbots don't host content, and so they can't take it down the same way that a website or a social media platform can. And there are some similar issues with other provisions that I flagged in my written testimony. Second, as currently drafted, the bill is at significant risk of being challenged in court for violating the First Amendment and for being unconstitutionally overvague. For instance, regulating outputs that relate to self-harm includes regulating outputs that discourage self-harm or provide resources, and that's likely to be found by a court to be overbroad. There are also other examples of this in my written testimony. And then lastly, HB 952 doesn't do enough to address the root causes of chatbot harms, which you got into a little bit with some of the questions beforehand. That really is the data use and targeted advertising, which is how chatbot companies do make money, and those are the root issue that's causing all of the devastating harms we're seeing. EPIC commends the legislature for working on this issue to address this urgent harm and would be happy to work with the committee on any amendments. Thank you.
Thank you. Aaron?
I think we're going to have John go first.
I guess that's okay.
Thank you, Madam Chair.
members of the committee. I'm John Favazza. I'm here today on behalf of the Entertainment Software Association. I'm joined by Aaron Siegel. He's with ESA as well. We're the trade association representing the video game industry. House Bill 952, as introduced, modeled after California, I think exempted the types of chatbots that are used in entertainment-based video games. So we were comfortable with the bill as introduced in that context. I think our concern is with some of the amendments added by the Economic Matters Committee. So I'll let Aaron talk about the types of chatbots that are in our games. I'll just focus on the amendments. First, and page 3, line 5 is where the exemption section is found. There was an additional exemption added to the legislation, and it was drafted in a way that I think made the exemptions read sort of circular in nature, and I'm not really sure they function as an exemption anymore. So we've submitted language to committee council, technical amendments, in our opinion, that just clarify the exemptions. The second part has to do with the language that was adopted from House Bill 1250, that you all heard, the cross-file being Senate Bill 827. And that begins on page 5, line 22, and it deals with the warning provision. And this bill is about companion chatbots. The defined terms are companion chatbots. This section that is borrowed over, and operators, right? They're the individuals that, create the chatbots. House Bill 1250 used different terminology. So this section applies to developers, not operators, and chatbots generally, not companion chatbots. So reading this language literally causes a great deal of confusion about what this bill actually applies to. So we're agnostic on which warning provision you all select. But I think in order to be consistent with the language in this bill, it would need to be narrowed to apply to companion chatbots and operators so that the language is consistent. With that, I'll turn it over to Aaron.
Thank you. Chair Beidle, Vice Chair Hayes, and members of the Senate Finance Committee. My name is Aaron Siegel. I'm here on behalf of the Entertainment Software Association. ESA represents the leading publishers and developers of the video game industry here in the United States, and I just want to talk about what video game chatbots do, and we've long incorporated chatbot-like technologies to enhance gameplay, storytelling, and player engagement. Interactive non-player characters, known as NPCs, AI-driven dialogue systems, and adaptive voice interactions are a key aspect of modern games. These features are low-risk, entertainment-focused, and fundamentally different from chatbots deployed in high-risk contexts, such as housing, employment, healthcare, or financial services, or the types of chatbots that the sponsor mentioned in his presentation. In video games, players knowingly and reasonably expect to interact with AI-driven characters. There's no meaningful risk of deception in this context, and AI is not masquerading as a real human being making consequential decisions about a player's employment, housing, or finances, and requiring the warnings labeled in the bottom parts of the bill would degrade the user experience without advancing consumer protection. I think we appreciate what the sponsor said about the California bill and that video games weren't quite the intent of what he was after. So with that, I thank you for our consideration, and go Orioles.
Thank you. Do I have any questions? Oh, Senator Kramer, you have a question?
Thank you, Madam Chair. Having heard the compelling testimony from Ms. Locklear and her expressing her concerns with regard to the language that is in the bill, I was just curious to find out, have you been able to find an opportunity to meet with the bill sponsor to discuss your concerns? Is the bill sponsor willing to even engage on this issue and discuss this matter?
Thank you so much for that question, Senator Kramer. We did have an opportunity to speak about them. They were proffered on the House side. I did highly encourage him to go ahead and redraft them, although that did not occur. So we came to the committee and shared our red line with you. So thank you for that question.
Okay, I was just curious. Thank you, Madam Chair.
You're very welcome. Senator Mounts?
Yeah, thanks, Madam Chair. I wanted to make sure I heard the testimony correct. So, Brianna, no?
Kara.
Pardon?
Kara.
Kara, I apologize,
That's
Kara.
okay.
So you support the bill as it was put out of the House, except for except for some other provisions. So your opposition to the bill is not consistent with the rest of the panel, is that correct?
The second half of that was correct. My opposition is inconsistent with the rest of the panel. I think in a broad stroke, EPIC's opposition to the bill is that when they tried to mash the two bills together, it became kind of functionally unworkable because they used some of the different definitions that the rest of the panel pointed to. But we have additional concerns to both 952 as it was originally drafted and the amended version because it creates potential for constitutional challenges and First Amendment issues and vagueness issues. And then our third concern is that it doesn't actually, we support the goal, but it doesn't actually address the problem that the sponsor identified.
So, and the next question would be, so if all the amendments were taken from your colleagues on the opposition panel, you would still be opposed to the bill?
Yeah, and it would be worse from EPIC's perspective.
Right.
Yes.
Thank you.
Thank you, Senator. Okay. Chairman. Margaret, can you unmute and give us your testimony?
Sure. Good afternoon, Chair Beidel and members of the committee. Margaret Durkin with TechNet, here to speak on House Bill 952. We echo many of the concerns that previous speakers raised. Specifically, we are concerned about the product liability provisions that were added to this bill. We did testify on House Bill 952 as well as House Bill 1250 in the House, where these new provisions came from. Our ask is for the product liability portions to be struck from the bill, and if not that, to provide clear safe harbors and limiting liability to knowing violations. We do think House Bill 952 is a good starting point. We did engage with the House ECM committee on some additional changes to the bill, but overall, that definition of companion chatbot is on its way to be more narrowly tailored. And for the reasons stated previously, I would ask that this committee strike the additions from House Bill 1250. Thank you.
Margaret, can you send us what you were requesting from the original bill? Did you say you had amendments that you requested on the original bill?
Yes, I do, and I can send that to the committee.
Okay, thank you.
Thank you.
Kyle, you want to go next?
Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the committee. My name is Kyle Seppi. I'm the State Policy Manager at the Computer and Communications Industry Association, or CCIA. We're a trade association representing communications and technology firms, and I'm speaking today to respectfully oppose HB 952 as currently drafted. We do share many of the concerns, as the previous witnesses mentioned, with this new draft of the bill. We do believe the bill should be amended to preserve the bill's original intent while making it more workable, constitutionally sound, and appropriately scoped. Specifically, we request that the 3-day complaint timeline be reexamined to ensure operational feasibility. And notably, the strict liability and private right of action combinations especially concerning and should be removed from the bill and limit liability to knowing violations. We believe that there should be clear definitions as well, more in line with federal and state privacy laws. And for those reasons, we urge the committee to reconsider moving this bill as currently drafted or consider amendments. Thank you.
Brianna January.
Thank you, Madam Chair, esteemed committee. Brianna January with the Chamber of Progress. In respectful opposition to HB 952, we are a center-left tech trade association. Unlike traditional trade associations, our partners do not have a voter veto on our positions. We engaged over on the House side on the bill as originally drafted. We were concerned then mostly about the bill's definitions and not wanting to catch mundane, genuinely helpful tools up in an overbroad definition. We are still concerned with definitions, as a lot of my colleagues have suggested, and we'd like to point to Utah's chatbot law and that is so tailored with their definitions that a lot of industry did not oppose, and Chamber of Progress, we did not even engage on that bill because we found those definitions to be very tailored to not unintentionally catch up things like a tutoring chatbot or a second language speaking chatbot, things like that. We also continue to have concerns with the amendments, as you've heard from my colleagues, mostly from the new PRA and strict liability that have been added to the bill. So at the very least, we strongly request that those be removed. But we are also seeking the amendments that you've heard from the rest of my colleagues in industry, and we look forward to continuing to work with the committee to get this right for Marylanders. And happy opening day. Thank you.
Thank you. Nathan?
Madam Chair, members of the committee, thank you so much for having me today. My name is Nathan Trail, and I'm the Vice President of State Government Affairs at the Information Technology Industry Council, or ITI. We respectfully oppose HB 952 because while it is very well intentioned, we do believe it could create serious legal, technical, and operational problems that could ultimately undermine user safety rather than improve it. The bill as written does create somewhat of a safety paradox by exposing developers to strict liability for imperfect outputs. It gives companies strong incentive to scale back or eliminate safety-oriented features altogether rather than risk lawsuits over tools that can never truly be flawless. The bill treats chatbot software like a physical product for liability purposes, even though generative AI outputs can be probabilistic. Context dependent, it's shaped by user prompts. That is a break from established tort principles and creates uncertainty far beyond this bill. The bill also relies on overly prescriptive requirements that are unlikely to work in practice. Constant warnings and repeated interruptions do not necessarily improve safety. In many cases, they create warning fatigue where users will stop paying attention to warnings altogether. The bill's requirements for real-time detection and quick complaint resolution may sound reasonable, but in practice, they would be very difficult to meet, especially for smaller developers. And finally, the bill's definition of companion chatbot is so overbroad, it could sweep in a wide range of conversational AI tools that it was never intended to cover. For those reasons, again, we respectfully urge the committee to reject HB 952 and instead pursue a stakeholder process that brings together technical experts, industry, and policymakers to develop a more workable approach. And with that, I thank you so much for your time today.
Thank you. And Haley?
Yes, thank you. Good afternoon, Chair, Vice Chair, esteemed members of the committee. Thank you for the opportunity to speak today. Like my colleague Kara Williams at the Electronic Privacy Information Center, I am providing unfavorable testimony today for perhaps different reasons than some of the others. I am Policy Counsel for Fair Play, an organization that works to enhance children's well-being by eliminating the exploitative and harmful business practices of marketers and big tech. Very enthusiastic about liability approaches, private right of action. I'm really here today to emphasize the need to really be incisive about the definitions in this bill. Like my colleague from EPIC, we have been working on SB 827, HB 1250, and are very enthusiastic about addressing this urgent problem, but want to make sure that the definitions and the requirements are sufficiently clear and avoid unnecessarily really bringing a provision like this into litigation where it doesn't need to be. States can and should be regulating these products, and we think that's critical. We also think a critical piece missing here is the data privacy piece, really drilling down to try to stop some of the initial data collections that then feed the features that make these types of products so harmful for children. So really want to emphasize that we don't want Maryland to miss the opportunity there to put in some limitations up front. These companies are being reckless and experimenting with our children as they did with social media. And so we do think, the legislature should take this issue up and get something across the finish line so we can get much needed protections in place for families. And I'm happy to, we attach some suggestions to a written testimony, but happy to work with the committee to advance a strong product. Thank you.
Senator Kyle, you have a question. Everyone is still in.
Yeah.
So if you want to direct it to someone.
Yeah, thank you, Madam Chair. I don't know if Margaret or Brianna may be the best, but I'm really think maybe Margaret, since you're there, since I see you there. I'm really curious about the strict liability, products liability standard that was put on this. And I know that there's some, at least components of the original bill that was based on California. And I know other states have passed something similar, but has any state incorporated this type of strict liability standard that's most often in products liability cases?
My understanding is that no other state has implemented or enacted legislation that has the strict product liability related to chatbots.
Okay. All right. Yeah, it's really, okay. Anyway, thank you. Thank you. I appreciate it. Thank you, Madam Chair.
Do I have any other questions for this panel? Seeing no questions, thank you all for your testimony. Very important testimony. Thank you. So that ends the hearing on House Bill 952. I think the committee has some work to do. And then we're going to go on. We have three what I think are pretty short bills. Senator Lamb's going to present House Bill 456, Howard County Alcoholic Beverages.
All right, thank you, Madam Chair. For the record, Clarence Lamb, Senator District 12, the Senate Chair of the Howard County Delegation, here to present Howard County HB 456, which is also Howard County 2-26 on alcoholic beverages and gift basket permits. This bill allows the Howard County Board of License Commissioners to issue a special permit to a business, number one, whose primary business is the sale and delivery of flowers. Number two includes the sale and delivery of gift baskets of flowers, food, and other items. And number three, who does not hold another alcoholic beverages license or permit. A permit holder could sell and deliver these gift baskets to consumers who are of legal drinking age. There are an estimated 15 businesses in Howard County that would qualify for this license. The bill prohibits these licenses from going to chain stores or supermarkets, and that is the bill. Would ask the committee for a favorable report on this bill.
Do we have any questions for Senator Lamb on House Bill 456? Seeing no questions, that ends the hearing on House Bill 456. Senator Washington, you have two bills for the Prince George's County delegation. House Bill 443, Prince George's County Alcoholic Beverages Class B SEC Small Event Center.
Thank you, Madam Chair. I'm going to ask Terrence, he's the Executive Director of our Liquor Board, to answer any questions, which I'm sure we won't have, on these two bills. I'll start with House Bill 443. For the record, Senator Alonzo Washington to present on House Bill 443. This bill establishes that Prince George's County a Class A, B, SEC Small Event Center beer, wine, and liquor license, and authorizes the Prince George's County Board of License Commissioners to issue the license to a small event center as specified. The license authorizes the license holder to sell beer, wine, and liquor for on-premises consumption to individuals attending an event at the event center as described in the license. The board may issue no more than 24 licenses in a license year, or allow 3 licenses to apply in each state legislative district in a county at one time. I, for those reasons, ask for a favorable report on this bill.
Thank you, Senator. So I don't really know the small event center. That's one place, the small event center?
There's multiple small event centers around the county, and the idea is to allow ones with small kitchens in them to be able to sell alcohol to their patrons of that establishment.
So each one would have 24 licenses?
Each one of those venues would have one license. Well, no. It depends if they qualify under the law, because there's still some stipulations that you have to qualify for. You have to have, I believe, a seating of over 100 folks, and you have to have a kitchen, and there's some other things that you have to adhere to according to the bill to qualify for it. So not all of these small event spaces will have it, or qualify for it, but the opportunity is there for about 2 to 3 or more venues to have it, to be able to have this license to sell alcohol on premises at their event space.
Thank you. I don't see any other questions on that bill. Let's go to your House Bill 611, Prince George's County Alcoholic Beverages Fees.
Yeah, thank you, Madam Chair. For the record, Senator Alonzo Washington here to present House Bill 611 on behalf of the Prince George's County delegation. This bill simply increases the annual fees for various alcoholic beverages, licenses, and permits in Prince George's County. In addition, the bill increases one application fee from $300 to $400 and license transfer fees from $500 to $550. Essentially, there's about a 10% increase on all the licenses in Prince George's County. There is no letter from the delegation on this bill yet, or the previous bill either. We held both bills, and we'll be taking a position on them next week during our Senate delegation hearing.
I was going to ask that question. So we won't vote those until we have letters. Thank you. Do we have any other questions for this? So, Walter, do you have anything you want to add?
No. Terrence Shepard, Director of the Board of License Commissioners for Prince George's County, for the record.
Today, we wait a few minutes and we'll be ready to vote. Give Tammy a few minutes.